Well, good afternoon, everybody. First of all, just like to thank, obviously, Travis for joining me on Sunday, and Mill, Billy and Dr. Siltman for joining me yesterday. But now we'll carry on with a look at one of the most important documents filed by Kathleen Zellner, and just do a read through this particular document. As I say, probably one of the most important that she has filed in Steve's case. So let's pop it up and see what we've got here. Interesting. It's almost a year to the day since the Clerk of Court of Appeals received this document, 150-page document, no less. So a lengthy piece of work by Kathleen Zellner. And let's just make sure everything is working as it should. I should trust it more, but you never know. You just never know. So let's just make sure that everything is working as it should. And yes, I've got an intruder, so I will say cheerio and bye-bye. Catch you later. Here we go. Yes. I think we're there. Oh, hi there, Alice. Hi, Doctor. Hi, I don't recall. So here it is, as I say, a year, almost a year to the day that this was filed with the Court of Appeals. Let's come on down and see what we've got here. State of Wisconsin versus Stephen Avery. An appeal from the orders. Oh, not a bit too far. Let's try it this way then. Let's try it this way. An appeal from the orders denying post-conviction relief and additional scientific testing entered in the Circuit Court of Manitowoc County, the very dishonorable Judge Angela Sutkiewicz, the presiding judge. Brief of defendant appellant Stephen Avery. And I think we get a few names here at the beginning. Yes, we do. We've got Kathleen Zellner and Steve Richards of Casco, Wisconsin. I actually looked at where Casco is. It's near that bit by the side of Green Bay that points off to the east. The sort of promontory that comes out of Wisconsin, and I think Sturgeon Bay area is nearby. That's Casco. So well north of Manitowoc, and very, very well north of Downers Grove in Illinois, just outside Chicago. Let's see, what have we got next? I think it's just an index next. Yeah, it's table of contents, table of authorities. We'll skip the table of authorities. It doesn't always make great reading. Let's just skip to issues presented, which I've actually got set up ready to go here. So here we go. Here's the issues presented section. And it's so important to remember what Travis was saying about the fact that the District 2 of the Court of Appeals, Neubauer, I think somebody called Davis is on that, Gundrum, and Paul Riley. Clearly they have decided they are not going to put up with judges who are supposed to be, if you like, the fair-minded referees in a game, being unfair and one-sided. And of course, it's interesting, isn't it, that the case was remanded back to Angela Sutkiewicz twice, and she decided that there was nothing needed. So I don't think we can be at all surprised that the very first thing that Kathleen Zellner points out to the Court of Appeals, basically saying to them, well, you know how you thought there were issues the same as we thought? Well, guess what? Angela thinks that you're wrong. She thinks that she knows better than you. Question 1. Did the Circuit Court, did Angela abuse her power in denying Mr. Avery's motion to vacate its October the 3rd, 2017 order and allow additional scientific testing? She answered no. She knows better than you. Did she abuse her power in summarily dismissing Mr. Avery's second motion pursuant to 97406 without addressing the 5 Brady claims raised, and in subsequently denying Steve's motion to supplement, which raised a 6th Brady claim, all of which deprived him of due process in violation of the Wisconsin and United States Constitution? The court did not address the 5 Brady claims. The court answered no to the 6th Brady claim. Did the Circuit Court err? That's a very polite way of putting it. As a matter of law, in failing to address Mr. Avery's claim of ineffective assistance of counsel, the Circuit Court answered no. Did the Circuit Court err as a matter of law in ruling that it was not authorized by statute to resolve claims of ineffective assistance of prior counsel, and that Mr. Avery would have to pursue that claim with the Court of Appeals pursuant to State versus Knight? The Circuit Court answered no. Did the Circuit Court abuse its discretion in dismissing Mr. Avery's second motion pursuant to 97406 without requiring the state to respond or conduct an evidentiary hearing? Well, she thinks that we're both wrong and that she knows better than us because she answered no. Did the Circuit Court err as a matter of law in applying the wrong standard to the newly discovered evidence? Guess what? She decided no. Did the Circuit Court abuse its discretion in ruling that the second motion of Mr. Avery, pursuant to Statute 97406, failed to show a sufficient reason as to why these issues could not have been raised in prior motions and is therefore barred by State versus 2 gentlemen with Spanish names, Escalona Naranjo. I hope I've done that justice. The Circuit Court again answered no. 8. Did the Circuit Court abuse its discretion by denying Steve's motion to reconsider and his 3 supplements to said motion, which included new evidence developed after his original filing on June the 7th, 2017? Again, she answered no. Item 9. Did the Circuit Court abuse its discretion in ignoring the subsequent briefs submitted by the parties incident to the motion to supplement? Again, she answered no. 10. Did the Circuit Court abuse its discretion by denying Mr. Avery's supplemental 97406 motion for a new trial pertaining to the discovery of human bones in the Manitowoc County gravel pit southwest of the supposed crime scene? Again, she answered no. Statement on oral argument and publication. Pursuant to Wisconsin Statute 809.22, appellant requests oral argument to facilitate review of the complex legal issues raised herein, some of which are believed to be of first impression. First impression, in other words, to look at stuff that has never happened before, this violation of the statute to preserve evidence, and for them to sneakily, behind everybody's back, without anybody knowing, thinking they were going to get away with it, handing back the bones. Pursuant to Wisconsin Statute Rule 80923, a publication is warranted because the case is of interest to the public and raises these issues believed to be of first impression. Let's have a look at the garbage that the state has presented. Statement of the case and procedural history. The state's case. In the 4 months before her murder, 25-year-old Teresa Halbach, Miss Halbach, had been to the Avery salvage yard to take photographs of vehicles 5 times. June 20th, 2005, August 22nd, August 29th, September 19th, and October 10th. Teresa worked for Auto Trader magazine and also had her own photography business. As we know, Auto Trader is a magazine that contains advertisements and photos of cars for sale. And I've actually bought a car through Auto Trader, and it was very, very good. We were very, very pleased. Anyway, I also bought a lot of cars from the local garage, which was even better. But anyway, we're digressing. Stephen Avery had arranged hustle shots with Teresa previously by calling her phone directly, as he did on October the 10th. Because hustle shots were not pre-arranged, the Auto Trader office did not know about such shots until they occurred when the billing took place. And as we know, a photographer earned more from a hustle shot than a shot pre-arranged through Auto Trader, and Teresa did many such hustle shots, which obviously is pretty important to do. This is just to do with how everything will be referred to in the document, and really, obviously, Circuit Court, that's Sheboygan Circuit Court, that's Angela, who was not very angelic, Superwitch. A. The state's timeline for October 31st, 2005, and witnesses. 12 minutes past 8 in the morning. According to the state, Mr. Avery called Auto Trader and spoke to Dawn Plitchker, Miss Plitchker, the Auto Trader receptionist, in an attempt to lure Teresa to the Avery salvage yard by setting up a photo shoot appointment for his sister Barb's Plymouth van. Steve called from his cell phone. Dawn Plitchker testified that the caller left the telephone number of 920-755-8715, the landline number for the Dassey Yander residence, and the Dassey Yander address 12930A Avery Road. 9:46 a.m. Dawn testified about an incoming call from Auto Trader to Teresa, allegedly leaving the Dassey Yander phone number and their address. However, 11:43, Teresa called the Dassey Yander number and left a message on the answer machine which stated, "I don't have your address or anything, so I can't stop by without getting a call back from you." 1:10. Teresa arrived at Stephen Schmitz's residence. The state, unsurprisingly, presented an incorrect timeline to the jury based on Mr. Schmitz's erroneous recollection that he received a call from Teresa at 1:10. However, Teresa's phone records show that she called Mr. Schmitz at 12:51. Therefore, contrary to Kratz's sweaty timeline, Teresa actually arrived 20 minutes earlier at the Schmitz residence than the state presented to the jury. 12:02 in the afternoon, Teresa called the Zipra residence and left a voicemail on the Zipra answering machine stating that she could not find their residence. This voicemail is missing and was never turned over to trial defense counsel. 2:24. The state claimed that as part of Mr. Avery's efforts to lure Teresa to his property, Steve used the blocked feature where the recipient of that call cannot tell who is calling. Teresa did not answer this telephone call, and Steve did not leave a message. 2:27, Teresa spoke to Dawn and allegedly informed her that she was on her way to the Avery salvage yard. The state provided no explanation of how the unanswered 2:24 call could have lured Teresa to the Avery property. 3 minutes later, Teresa told Miss Dawn that she was on her way to the Avery property at 2:27. Again, the state never explained how Teresa learned of the Dassey Yander address. The telephone records of Auto Trader, Teresa, and Mr. Avery, Steve, do not show contact between Teresa and Steve from 11:43 to 2:27. But Teresa's text and computer messages were never retrieved by the state. 2:35. Steve placed the second blocked call at 2:35, but the call was never connected. Between 2:32 and 2:45, the state's primary witness was Bobby Dassey, who testified that he was asleep and woke up around 2:30 and looked out of the kitchen window of the residence. Bobby testified that he saw Teresa's RAV4 pull up, Teresa exit the vehicle and start taking pictures of Barb's van. When Teresa finished photographing the van, Bobby saw her walking up towards Uncle Steve's trailer. Bobby then took a shower, and when he left the property at about 2:45 to go bow hunting, he saw Teresa's RAV4 was still on the property, but he did not see her. Based upon Bobby's testimony, the state claimed that Steve was the last person to see Teresa alive. 2:41 to 2:43, 2-minute gap. Teresa's records indicate that a call was actively forwarded at 2:41 using the call forward no answer feature. After the 2:41 p.m. call on October 31st, there are no other such messages left. Rather, the subsequent calls are voicemails without that feature. The 2:41 p.m. call to Teresa's phone pinged off the Whitelaw Tower, which is, I presume it still is, or maybe it's not there anymore. Okay, which was 7.8 miles from Steve's property. 3 o'clock. Scott Taddick, Mr. Taddick, Barb's boyfriend, testified that at about 3 o'clock, he went bow hunting in Kewanee, and as he drove on Highway 147 going west, he saw Bobby driving east. Much later on, between 3:46 and 3:47, Bobby's brother, Blaine, testified that at approximately 3:46 or 3:47, after he got off the school bus and was walking home, he saw Steve place a plastic bag in his burn barrel, and the barrel had white smoke and flames coming out of it. The state prosecutor, the disgraced former attorney and sexting pervert, Ken Sweaty Kratz, claimed that by 4:35, Steve had burnt Teresa's electronic devices in his burn barrel. 4:35, according to the state, Steve placed an alibi call to Teresa's phone from his landline. Between 4:45 and dusk, Mr. Robert Fabian, a friend of Earl Avery's, testified that he saw smoke and smelled plastic being burnt in Mr. Avery's burn barrel around dusk. Of course, that was something that Millbilly was pointing out. There would have been smoke coming from the bush that he was burning. Anyway, 7:30 to 7:45, Mr. Taddick testified that he saw a large fire in Steve's burn pit with flames reaching above the roof of the garage, and he saw Steve standing by the fire. The state claimed that Teresa was already murdered by this point, and Steve was in the process of destroying, mutilating, and burning her body in his burn pit. 11 p.m. When Blaine got home from trick or treating, he testified that he saw Stephen Avery sitting there watching the fire, and that the flames were about 4 or 5 feet. The state's forensic evidence. The state's case against Mr. Avery, Steve, was based almost exclusively on circumstantial planted evidence. The critical facts related to the state's forensic evidence are as follows. November the 5th, 2005, Teresa's RAV4 was discovered on the southeast corner of the Avery property by 2 civilian searchers, Pamela Sturm, Pam, and her daughter Nicole Sturm, Nicole, within 30 to 35 minutes of their arrival. Now, according to the state, the speed with which Pam located Teresa's RAV4 on the Avery salvage yard was attributable to, get this, the hand of God. That so reminds me of 1986 World Cup quarter-final versus Argentina. Diego Maradona scores a goal with his hand, later describes it as the hand of God. You know, I think that the Almighty has got more important things than guiding Pam to the RAV4. And I think we all know that. And it was a very, very, very bad thing that she said. I do believe that God directed the way. Teresa's RAV4 was locked and partially obscured by branches, plywood, and an old vehicle hood. According to the state, the RAV4's battery had been disconnected to prevent the alarm from being activated. The state argued that it was readily apparent that Steve intended to crush the RAV4 simply because the RAV4 was found in the vicinity of the car crusher. Also, the state contended that the RAV4 could not have been driven onto the Avery property from the Redant pit because of the 15 to 20 foot high berm immediately to the south of the RAV4, which would have prevented entry from the Redant pit onto the Avery property. November the 6th, 2005, Deputy David Siders found a tyre rim in Steve's burn barrel. Underneath the tyre rim, Teresa's electronic devices were discovered, including her Motorola V3 Razr, cell phone, the circuit board for her Palm Zaya 31 Palm Pilot, and components of her Canon PowerShot A310 digital camera. Inexplicably, there were unburned cans and unscorched foliage in the burn barrel. November 7th, 2005. The Wisconsin State Crime Lab discovered 5 small blood drops in Teresa's vehicle. Also, a DNA profile of Steve was obtained from these drops, these 5 small drops. November the 8th, human bones, a tooth root fragment, and rivets from a pair of jeans were found in the burn pit behind Steve's garage, and a RAV4 key was found in Steve's trailer. Steve's DNA profile was recovered from the RAV4 key. The RAV4 license plates were discovered in another vehicle at the salvage yard during a search by a volunteer, but the male DNA on the plates was insufficient to develop a full DNA profile. November the 9th, 2005, Steve is arrested and charged with possession of a firearm by a felon. November the 15th, which I believe was the day that either Kucera or Vogel were supposed to be deposed, give a deposition, Steve is arrested and charged with first-degree intentional homicide for the murder of Teresa Holbach. March the 1st to the 2nd of 2006, 4 months later, based on Brendan Dass's alleged confessions, law enforcement conducted a search of Steve's garage and discovered fragments of 2 .22 caliber bullets, item FL and item FK, that had somehow gone undetected during 6 previous searches, November the 5th, 6th, 8th, 9th, 10th, and 12th of 2005. And to celebrate the fact that they had finally found this evidence, Prosecutor Kratz held 2 press conferences where he disclosed in great detail that Brendan had confessed to everything. March the 8th, 2006, the state filed an amended information adding the charges of sexual assault, kidnapping, and false imprisonment counts. April the 3rd, 2006, the hood latch of the RAV4 was swabbed. Apparently. Well, it might have been swabbed, but we don't know what swab it was that made it to crime lab. May the 8th, 2006, Sherry Culhane, of that wonderful head of hair, confirmed that item FL had Teresa's DNA on it, and the profile developed from the hood latch matched Steve's DNA. June 15th, 2006, the state attempted to interject 9 items of other acts evidence into its prosecution to corroborate the amended information filed on March 8th, 2006. Now, these 9 acts consisted of 2 alleged acts of physical violence against women and 1 against a cat, 1 act of reckless endangerment, 1 act of a convicted felon in possession of a firearm, and 3 alleged acts of improper sexual behavior, and 1 act of a phone conversation of an alleged sexual nature. Bet that all got Kratz excited. September the 22nd, 2006, the trial court ruled against the state's 9 other acts evidence, holding that it failed to find any meaningful relationship between the other act's evidence and the charged offences. In the trial court's opinion, we're talking about Willis here. So, okay, this is fair enough, Willis. You're doing your job here. The other act's evidence had virtually zero probative value, would be highly prejudicial, and was clearly inadmissible. Certain things that even Judge Willis cannot bend over backwards to help the state with. February the 2nd, 2007, the state filed a second amended information dropping the charges for sexual assault and kidnapping. At the beginning of the trial, the state convinced the court to instruct the jury about a party to a crime theory of accomplice liability as to the homicide, mutilation of a corpse, and false imprisonment charges then to be tried. Mr. Avery's blood in the RAV4 was not planted, according to the state. Approximately 1 to 2 millilitres of Steve's blood, allegedly from an actively bleeding finger, were discovered in the RAV4 in 5 places, i.e. on the driver's and passenger's seats, rear passenger door jamb, a CD case, and by the ignition. Blood flakes were found on top of the driver's side carpet. There was no corresponding stain under the blood flakes. The state claimed that no one in law enforcement had access to Mr. Avery's blood prior to November the 5th, 2005 to plant it. The blood from Mr. Avery's bathroom was collected after the RAV4 was removed from the Avery property. Also, the state argued that trial defence counsel had failed to demonstrate exactly how the police could have planted Mr. Avery's blood in the RAV4 because of the, quote, the sheer volume and, quote, sheer number of places where the blood was discovered. Kratz emphasized that Steve's DNA profile from his blood in Teresa's vehicle came from the cut on the middle finger of his right hand, which occurred during his struggle with Teresa. The state's blood spatter expert, Nick Stalke, agreed in his testimony that the ignition stain was consistent with somebody who could be actively bleeding on their right hand. But clearly he didn't do an experiment, a simple experiment similar to Kathleen Zellner's. In his closing, Sweaty Prize stated that the stain was absolutely consistent with somebody with a cut to the outside of the right hand and turning the ignition. The state, through its expert, Dr. Mark LeBeau, attempted to rule out the 1996 blood vial as a source of Steve's blood in the RAV4. The blood in the 1996 tube was preserved by using EDTA. Mark LeBeau tested 3 of the 6 swabs from the RAV4 and claimed there was no EDTA in them. Again, I think that's called dry labbing, when you don't test everything. You just assume, and we know that assumptions are the mother of. Teresa's blood in the RAV4. Nick Stalke, the state's blood spatter expert, claimed that after Teresa had been shot, she was thrown into the rear cargo of the RAV4, causing impact spatter on the inside of the rear cargo door. According to Nick Stalke, Teresa left a hair imprint from her bloodied head on the side panel of the interior of the rear cargo area. The bloody hair component, however, it is consistent with a bloody object, such as a body being imploded into the rear end of this vehicle. There was no mixture of Steve and Teresa's blood, even though Steve allegedly tossed Teresa into the RAV4 as he was actively bleeding from his right middle finger. Despite the blood in the interior of the RAV4 being linked to Mr. Avery, there were no fingerprints of Mr. Avery on the interior or exterior of the RAV4, even though the state's fingerprint expert, Mr. Riddle, claimed that someone with sweaty hands was more likely to leave prints than someone with dry hands. That's fair enough. Sweaty Price contended that Steve touched the hood latch with sweaty hands when he left his DNA profile. Mr. Riddle testified that he discovered 8 prints on the RAV4 that were suitable for comparison, and one of the 8 latent prints contained a palm print. That must be item A23. The prints were located where the key for the cargo gate is inserted, along the pillar that goes along the tail assembly, on the other side of the reel cover, inside a rear passenger window, and on the hood. Mr. Avery was not matched to any of those 8 prints. The state never claimed that Steve was wearing gloves. Mr. Riddle was never asked to examine the shell casings found in Mr. Avery's garage for fingerprints. The shell casings were never linked to item FL. A blood stain, A23, from a male on the rear cargo door of the RAV4 did not match Steve either. No blood of Teresa in Steve's trailer, garage, or on the rifle. There was no blood of Teresa in Steve's trailer, garage, or on the rifle in his bedroom that was allegedly used to shoot Teresa in the head. Steve's DNA on the RAV4 key. Between November the 5th to the 9th, there were 7 searches of Steve's trailer. On the 6th entry, on November the 8th, Teresa's Toyota key was observed for the first time next to Steve's bookcase in his bedroom. The state contended that Steve kept the key so that he could move the RAV4 to crush it. During the November the 8th search of Mr. Avery's bedroom, Manitowoc County Sheriff's Department crackerjack detective Sergeant Andy Colburn. Hey, here comes Andy. Hey, aren't we glad to read about you, Andy? Conducted an hour-long search of Steve's small bookcase. He would have known every single tiny piece of wood on that bookcase if he had examined it for an hour. Our crackerjack detective testified that he tipped and twisted the bookcase, pulling it away from the wall. With his disgust at this piece of evidence, Sergeant Colburn testified that he forcefully pushed the photo album into the bookcase, causing the Toyota key to fall out of the back of the shelf. But Andy never explained how the key moved from behind the shelf to a spot on the northwest side of the bookcase by Mr. Avery's slippers. During Andy Colburn's interaction with the bookcase, this is laughable, isn't it? During Andy's interaction with the bookcase, Lieutenant Lenk left the bedroom. But when Big Bad Jim Lenk returned, he noticed a Toyota key had suddenly appeared by the northwest side of the bookcase on the carpet. Neither side subpoenaed the bookcase for trial. The state admitted that even if the key was planted, as trial defense counsel claimed, the jury should, quote, set the key aside because there was, quote, enough other evidence of Steve's guilt, and that, quote, the key in the big picture, in the big scheme of things here, means very little. You wish, Grants. The state relied upon Sherry to explain the absence of Teresa's DNA on her own key by explaining that the last person to handle the key was the most likely source of the DNA. Sherry testified that there was no mixture of Teresa and Steve's DNA on the key because, quote, if you have someone who's a good shedder, and sheds a lot of DNA when they touch something, a lot of studies show that is going to be the last person is going to be the DNA you pick up. Teresa's body burnt in Steve's burn pit. The state relied upon the testimony of forensic anthropologist Dr. Eisenberg to claim that Teresa was burned in Steve's burn pit. Leslie testified that the primary burning episode was in the burn pit behind Steve's garage and that at least a fragment or more of almost every bone below the neck was recovered in that burn pit. Leslie stated on cross-examination that there is evidence from the Avery property that there was transport of human bone, and I believe that transport occurred from the original burn pit and adjacent areas to barrel number 2. So we've not just got keys that migrate, we've also got bone fragments that migrate. Incredible. It must be something about the aliens lurking around the salvage yard. Leslie identified the bones designated by Calumet County evidence tag 8675 as being located southwest from the Avery property, which is called the Manitowoc County Gravel Pit. Leslie testified that her second report was a spreadsheet of tag numbers and the evidence collected under each tag number. Leslie admitted that one bone fragment from the Manitowoc County Gravel Pit appeared to be a human pelvic bone with a long linear cut on either side of those two bones that were still in proximity. Leslie, in describing the suspected human pelvic bone, stated that it was clearly a joint articulation at the right side of the pelvis, where the pelvis meets the lower part of the spine. In the closing, Ken stated that he would take 20 seconds to talk about the possible human pelvic bone in the Manitowoc County Gravel Pit. He said that these bones were possibly human, so it means that we don't know what it is. Leslie didn't know what they were. Dr. Fairgrieve didn't know what they were. Dr. Scott Fairgrieve was the trial defense counsel's forensic anthropology expert. Some larger human bones were found in the Dassey-Yander burn barrel evidence tag 7964. Leslie described a human scapula, portions of a spinal column, metacarpals, and a fragment of long bones in the Dassey-Yander burn barrel. The bones found in the Dassey-Yander burn barrel also exhibited evidence of cut marks. Leslie claimed that when she opened the container of bones from the Dassey-Yander burn barrel, she got a waft of flammable liquid or fluid, but did not smell burnt rubber from tires. Kratz admitted the bones were moved, but claimed the big bones were moved by Mr. Avery from his burn pit to the Yander burn barrel a couple hundred feet away, just for the fun of it. Special Agent Thomas Sturdivant, the one who at trial said if anyone's to blame for the lack of photographs, it's me, testified that the burn pit bones were intertwined or mixed in with the steel belt from the tires. Prosecutor Kratz stated in his closing, the bones being intertwined and mixed in is the state's or one of the state's strongest argument for this being the primary burn site. The state claimed the Wisconsin Department of Justice Division of Criminal Investigation, DCI agent Rodney Pivito, ruled out the smelter and the wood burner as other possible burn sites on the Avery property. The state called DCI agent Kevin Heimel to testify that the investigators found 5 out of the standard 6 gene rivets marked Daisy Fuentes in Steve's burn pit. The state referenced Katie Holbach's testimony that Teresa had Daisy Fuente brand genes that were missing after her disappearance. Cause of death: 2 gunshots to the head. The state claimed that Steve backed Teresa's RAV4 into his garage, closed the garage door, placed Teresa in the rear cargo area, then removed her from the RAV4, laid her on the cargo floor, and shot her in the left side and back of her head. Leslie testified that the defect in the parietal bone above the left ear showed the characteristic sign of an entrance bullet wound, and a second defect in the occipital region showed Teresa was also shot in the back of the head with a .22 caliber gun. Additionally, the state relied on Mr. Olson, a trace metal expert, who testified that x-rays of the skull defects in the parietal region showed particles of lead. On November the 6th, 11 spent shell casings were found in Steve's garage, but were never forensically linked to either FL or FK, the bullets, or any items of evidence in the case. The state claimed that Steve cleaned the garage, but his DNA was detected on the garage floor. Teresa's DNA on the bullet, FL. There were 2 damaged bullets eventually found on on Steve's garage floor on March the 1st and 2nd, 2006. Sherry, the state's DNA analyst, performed DNA testing on both bullets, and DNA was only found on one. After visually examining FL and observing no signs of blood, Sherry washed the bullet in a buffer solution and developed a DNA profile matching Teresa. But Sherry was not able to determine the source of the DNA and testified that she could only determine that the DNA came from nucleated cells. Red blood cells do not have nuclei, so the DNA did not come from red blood cells. The state explained that Sherry's contamination of the control sample for item FL with her own DNA during the testing process did not diminish the results of Miss Culhane's DNA comparison and subsequent identification of Teresa's DNA. The state ballistics expert, Mr. Newhouse, opined that the bullet containing Teresa's DNA was fired from the .22 Marlin Glenfield rifle mounted above Steve's bed. Mr. Newhouse worksheet did not indicate he performed a trace examination of item FL. The state's forensic pathologist, Dr. Jensen, testified that Teresa's cause of death was the result of 1 or 2 gunshot wounds to her head. Specifically, Dr. Jensen testified that Teresa's DNA got on item FL when it traveled through her brain, causing her death. Leslie testified that there was no evidence of other gunshot wounds to the bones from other parts of Teresa's body. The state, in relying upon Dr. Jensen and Leslie's opinions, told the jury in its closing that Teresa was killed by gunshots to her head. Mr. Avery's DNA on the hood latch. The state claimed that Mr. Avery wanted to deactivate the RAV4 alarm, so he disconnected the battery cables after he opened the hood, touching the hood latch and leaving his DNA. Prosecutor Kratz told the jury that this DNA came from Mr. Avery's sweat. There was no witness description of Mr. Avery sweating on October the 31st, 2005. Sherry never mentioned sweat in her hood latch testimony. Leg irons and handcuffs were seized from Steve's bedroom. Sherry confirmed that there was no DNA of Miss Holbach on the leg irons or the handcuffs, but there was a mixture that included Steve's DNA. Sherry agreed that this meant these items were not wiped down with bleach. Steve's mattress tested negative for blood, as did his knives. No hair from Teresa was found in Steve's residence, including when the vacuum cleaner was checked. On March the 12th, 2007, the state dismissed the false imprisonment charge. Finally, for now, we're at page 22. So we've still got a fair few to go because we're only at page 38 of 150. Only one person committed the crime. Kratz, in his rebuttal, told the jury, quote, "It's not a difficult decision that you have to make because everything in this case points towards one person, towards one defendant." Well, I'm sure you'd agree that there's some absolutely iconic quotes there that will be permanently etched, indelibly etched in our memories. And as I say, interesting, isn't it? It's a 1 year anniversary of when that motion was filed, and I've read it through quite a few times to try and get a sense of the mood of Kathleen Zellner. And I think that we can definitely detect Kathleen Zellner's controlled rage at the state, and particularly Sutkiewicz. Anyway, I'm going to say cheerio. So hi, Millbilly, Alice, T1. Hope you're enjoying that spanner. Dr. Silkman, yes, great to see you all here. Oh, yes, Ronald. I don't recall. Mose, Anthony, hi. Let's see who we've got here. Mose, I don't recall. Kelly, hi, Kelly. Great stuff that Kelly's doing, a series of videos, by the way. I'm sure you've been following those. What I'll do, Kelly, is pop a link to your channel in the description so that if people haven't gone across to have a look at it, then hopefully they will. Sean, hi Sean, and Sherry, Disco Perfect. Yes, who else have we got? Millbilly. Dr. Silkman, Sherry. Yep, I think we've got all the. Oh, here's another name, Carla Black. Hi, Carla. Sherry again. Sean, Kelly, Carla, Millbilly. I think that's everybody. Not. Yep. And of course, if you're watching and you don't feel that you want to add a comment, that's fine. But it's always nice to see new names appear. Just pop your name in there, just say hi, and we'll see who you are. Okay. Anyway, till next time. Tomorrow I've got a live chat with an accordionist, a good friend of mine, fellow competitor at Perth. So I'm going to have a chat with Liam. But if I get the opportunity to do something earlier on during the day, then we'll do the next part, because I really enjoy reading what Zellner. If we don't have the opportunity to hear what she's saying, second best thing is to read it, even if you've got to put up with me reading it. So catch you all again soon. Bye for now.